All right, good morning, everyone. We're going to get started here. Thank you for joining us today. I am Amy Murphy. I'm a litigator at Miller Johnson, and I have my colleague James Buster with me. He's a fellow litigator at Miller Johnson, and we are presenting today as part of our not quite monthly, a little bit more frequently than that, series, Lessons from Litigators. We are going to present today on a pretty interesting topic, force majeure clauses, which in today's age are particularly relevant for reasons we'll get into in this discussion. So without further ado, we'll get started. Our topic is acts of God and man when the unforeseen destroys a contract. James, you want to kick us off on the topics that we're going to hit today?
Absolutely. But of course, first and foremost, remember, this is not legal advice. This is just two attorneys giving some general interesting information about what happens when a contract gets destroyed by events you do not foresee. All right, so today's topics, as Amy led on, force majeure clauses, also known as excused performance clauses. Today, we're going to talk about what they are, what do they say, why do they matter, why do you want one, and how do the courts interpret and apply them? And then, of course, at the end, we will provide some conclusions and takeaways and bite-sized pieces for when you separate from us and go on with your day. And with that, Amy, I'll turn it back over to you.
Thanks. So force majeure, we were just talking this morning as we were getting going in this presentation. What an interesting phrase it is. It's a French term that literally means superior force. It actually entered the legal lexicon in the 1850s. And force majeure refers to an event that can be neither anticipated nor controlled. It's usually an unexpected event that prevents someone from doing something or completing something that they had agreed to do. So many of you listening today, I'm sure, have these clauses in your contract and have read them and thought about them and probably pulled them out during COVID to see what exactly they said. Today, what a court would say is that a force majeure clause is a contractual provision that excuses one or both of the parties from performing under the contract when certain unforeseen events outside of the parties' control occur. And there's a little bit of an oxymoron in here. James and I were talking about this yesterday because the point of a force majeure clause is to negotiate in advance some event that we tend to think of as unforeseen or unpredictable. So you're sort of predicting or foreseeing the events that under your force majeure clause, you'd say, we really couldn't have, seen it coming. And yet you're controlling for it in the contract. These clauses normally focus on events. Could you advance the slide, please, Jeff? Such as acts of God, war, insurrection, strikes, and the like.
All right, so what do one of these look like? We're going to give you the classic example from 30 Williston on contracts. Of course, I'm not going to read it to you, but you'll see that they can be kind of long. And as we'll see later, there are ones that are definitely longer. And they can be a little confusing with different standards. You'll see words like inadvisable, illegal, impossible, civil disorder, curtailment of transportation facilities, whatever that means, and government regulation and terrorism. Next slide, please. So you'll find that these clauses tend to be long, they tend to be convoluted, and they're almost a bit of an afterthought, trying to throw the kitchen sink, trying to think, what is it that we can't think of that can possibly happen that we can try to account for to deal with later. But why do parties try to put these in? Next slide, please. They are a way to allocate risk. Of course, you cannot foresee all risks, hence why we have this type of doctrine in the courts, but it allows you to do your best to think of, okay, what might happen? What can I deal with? What can I deal with? And what am I going to do about it? And most importantly, they allow you to excuse your performance under the contract, because otherwise you still have to perform. So why do these matter? Unlike other common law defenses to contract performance, such as some of the ones listed here, these ones are included in the contract. Force majeure clauses are contractually based. These other doctrines are something that you present an issue to a judge, and a judge will look at it and say, okay, well, was this impossible? Was the purpose frustrated? Was it impracticable? All of these are kind of terms of art. They have special meanings in the law, but all of them are just the judge looking backwards after the fact and trying to apply these principles. The Force majeure is your attempt and your ability to try to inform the judge ahead of time. What do you want the judge to consider? What are your intentions? What are the things that you guys want to allow you to be excused in the event that they occur? Next slide, please.
Yeah, and if we could just pause here for one moment, James. The thing that I think is interesting is we, during COVID, people were thinking about those common law defenses or doctrines that James brought up: impossibility, frustration of purpose, impracticability or commercial impracticability under the UCC. And the thing to remember with any of those doctrines is because they are common law, aside from commercial impracticability, which is codified in the UCC, they tend to be clunky. That's just the nature of the common law. It develops incrementally, it's case by case. And those doctrines may not fit particularly well your situation. And so that it really is powerful to have the force majeure clause and that negotiation with your with the other parties to the contract, because you can really tailor the clause to address whatever risks you see and your the other parties see coming down the pike. It's a little bit more insurance, I think, than relying on those older common law doctrines, which may work but may not work quite as well as you'd like when the unforeseen or event you can't control actually comes to pass.
And of course, because those doctrines, those other doctrines are under the common law, they will vary from state to state. They'll have similar themes, but they will vary in their specifics from state to state. So if you're a multinational corporation or a multi-state corporation, I should say, the way Florida might do it might be different from the way New York will do it, might be different from the way Michigan might do it. So having the force majeure and having a contractually based clause, again, can help kind of narrow that playing field. So these force majeure clauses are important because they really can save the company's bacon if things go south. And some crazy things can go south, as we'll learn about in a later case. $1 billion can be at stake, right, if things change. But it is important to remember that, and we'll get into this in more detail later, that if an unforeseeable event occurs and you are excused from performance, that doesn't mean you can kind of sit on your hands and say, well, it sucks for you, buddy. You have to still try to alleviate kind of the pain and suffering that the other side might feel. And like I said, we'll get into that in more detail later on.
All right, so how do courts interpret and apply force majeure clauses? And this is probably why you all joined us today, because you can write it as well as you can. And then the question really becomes, what's going to happen if you actually have to rely on it to write a notice to your counterparty to the contract, asserting that there's a force majeure event that occurred, and potentially wind up in court addressing whether the issue that's come up really did prevent performance and whether your force majeure clause properly accounted for that event. So in general, courts generally do recognize and apply these clauses. And in doing so, they apply your typical general contract interpretation principles. In most states, that means, and really, I beg to find a case or a court that doesn't feel this way. The court's going to look to the plain language of the contract and hold the parties to the intent that they had when they contracted based on what they wrote down. Interpretation and enforcement vary by state, as James just mentioned. Courts tend to apply force majeure clauses narrowly in favor of preserving the contract. And that's because courts really do feel that the contract is key and you've obligated yourself to perform in some way. So the force majeure clause, no matter how broad you try to write it, the court's going to look at it and each term will be narrowly construed. Courts are, and this is important in the age of COVID, courts are skeptical of economic hardship arguments. And we'll get into some cases here in a minute to sort of flush out what's going on there. But generally speaking, if you come in and plead as your excuse to performance that it just became unprofitable based on economic conditions, and that's the force majeure event that excuses your performance, courts are not going to love that typically. There are some courts though, and we'll get into this case, Old Carco, in a few minutes. Some courts have said, okay, a change in economic conditions could be a proper basis for a force majeure clause. But, and here's the important thing, it's only when that change in economic conditions is expressly identified in the contract as a force majeure event. If you're relying on other terms, but sort of baked into those terms is the notion that the economic hardship is really what caused you to stop performing. You made the financial calculus that it didn't make sense to continue performing because you might start breaking other covenants you have. You might be threatened with bankruptcy. You know, that's going to be difficult to persuade a court that that's a force majeure event. And we'll get into that in some detail. The other thing that we'd like to highlight, and this is key, is that vague language and catch-all provisions may be counterproductive to your purpose. And that's for the reason that we've stated, and we'll show it in these cases coming up. Courts really do narrowly construe the terms of your force majeure clause. You can write the broadest catch-all, and a court's probably not going to pay much attention to it, and in some cases address it and specifically disregard it in favor of looking at the terms that you did concretely consider and include when you negotiated your clause.
And so with that, although there are many, many, many cases out there that talk about force majeure, we're going to focus on three. Kyocera Corp v. Hemlock Semiconductor LLC, because it is based in Michigan. Route 6 Outparcels, because it is based in New York, although it is applying Pennsylvania law, but New York courts tend to deal with a lot of force majeure clauses. And then we're also dealing with Old Carco, because they were one of the few courts to actually allow a party to be excused from performance because of economic conditions. All right, so Kyocera Corp. So we're going to kind of use up 2 slides here, but I'll give you a second on this. This is an example of an incredibly long force majeure clause. In fact, what you're seeing is only part of the force majeure clause. I did not want to torture you with 3 or 4 slides of force majeure. But as you can see, there's a lot here. There's a lot for a court to unpack, which is not always productive. You want to be thorough, but at the same time, the more words you put in there, the more opportunity there is for misunderstanding. You can go back to the original slide.
Yeah.
Thank you. So as you might notice in here, and again, it's kind of buried because it's so long, it does use certain phrases such as neither buyer nor seller shall be liable for delays or failures in performance of its obligations under this agreement that arise out of or result from. And then it lists a few different potential things here, including, interestingly enough, epidemics and quarantine restrictions. In this case, it's actually from 2008. So very good forward thinking for them. But that arise out of and result from language sounds pretty broad, right? You might think, okay, well, we've told the court if it arises out of a result of something we can't control, then that's when we want to be excused. And these other things are just kind of examples for you, Judge, just some examples of what we're kind of thinking here. Now we can move forward with the slides. In this particular case, we had a take or pay contract. And essentially what that is the buyer says, I'm going to pay you a certain price for these goods over time, no matter what the market does. And the seller says, great, I'll also sell those for this specific price over a number of years. In this case, these were 5 to 10 year contracts for a semi-silicon. I've never been able to quite pronounce the word right. Polysilicon, there we go. It's because I always have it backwards. Polysilicon, which is apparently used in solar panels. And they would do these long-term contracts to pay for these. And of course, what happens here is there's a certain risk of the price going up or down. And of course, depending on which way it goes, either the buyer or the seller takes the risk. Well, in this case, a trade war eventually erupted between the US and China. China had started to dump loads of this polysilicon onto the market, reducing prices, making them crash. The US responded with tariffs, causing prices to skyrocket over time. The plaintiff in this case, which was a Japanese company, said, Judge, this is just so expensive. And because of this US government action, which was in the force majeure clause, arising out of government action, because of that government action, those US tariffs, we should no longer have to perform. We couldn't control what the US government or the Chinese government do. And and there's an uncontrollable event that's occurred. And so we should be excused. But the court disagreed, and it disagreed on a few grounds, but probably the most prominent, easy one to describe here is that there was no act of government that directly prevented the plaintiff from performing. And this is important here because the court essentially required a first degree contact between the force majeure event and the inability to perform. So what does that first degree contact mean? It means the court was looking for the government to say, you, Mr. Plaintiff, cannot do this, or it is now illegal for you to sell this in the market or to buy this in the market, a direct impact by the government. That wasn't the case here. You had the government doing something, which caused something to happen over here, which caused another thing to happen, which led to this lawsuit. And again, this broad language, arise out of, result from, although broad, didn't save the plaintiff here. So this is a really good example of the court applying pretty narrowly the language in the clause and applying this causal connection requirement very, very narrowly.
One interesting thing about Kyocera is the court signals what the parties could have done, and in particular what the buyer could have done differently. So the court notes that the plaintiff in the case could have opted to contractually limit the degree of market price risk that it was willing to assume with a ceiling or a floor, and it didn't. And the court also said that the plaintiff could have negotiated in the force majeure clause as a force majeure event, the event in which it becomes so unprofitable to keep purchasing because of government market manipulation. So the court's sort of, signaling to the plaintiff, you really could have specifically identified some events. And in a fixed price contract, you can contract the limit of market price risk you're willing to take on. And you didn't do either of those things. So.
Exactly. And I do want to add, Kyocera is actually a pretty important case on this topic in Michigan, because Michigan does not have, based in its common law, i.e. going back 1800s, a theory on force majeure. So it tends to borrow it from other states. And so to have a published decision from the Michigan Court of Appeals kind of laying out the analysis and how Michigan courts are going to interpret these clauses is very, very helpful.
All right, so the next case in our set of 3 cases that we're going to talk through this morning is Route 6 Outparcels versus Ruby Tuesday. In Route 6, there was, and this is a Supreme Court Appellate Division case out of New York, applying Pennsylvania law. But as James mentioned, New York tends to look at force majeure clauses in more frequently than in Michigan. So we do like to look at New York cases, no matter the law that's applying. But here it is Pennsylvania law that applies. In Route 6, there was a lease agreement, and the defendant had agreed, Ruby Tuesday had agreed to open a restaurant, build a restaurant, open it, and pay rent, including some sort of portion of the profits of the restaurant to Route 6 as the property holder. And then the Great Recession hits, and Ruby Tuesday continues to pay the rent, but doesn't build the restaurant. Ruby Tuesday tried to argue to the court that the Great Recession itself was a force majeure event outside of the control of Ruby Tuesday that prevented it from performing under the contract. The court said, nope. And just as in Kyocera, as James mentioned, the court really required there to be this first degree contact, sort of a similar analysis to how closely connected was your inability to perform and the force majeure event itself. And the court in Route 6 said, look, the defendant, of course, didn't have control over the world economy, but ultimately the defendant did have to decide how it was going to cope with that economic downturn. And it made the decision that it was going to pay the rent, but not build. And that was within Ruby Tuesday's power and control. It was not the sort of uncontrollable event that causes a party to fail to perform and gets excused. And we skipped over the slide here. Let me just go back a second to show you. There's their force majeure clause. Again, a pretty lengthy clause attempting to be really broad. You can see some language in here that we see in a lot of force majeure clauses, that it's really meant to address any cause beyond the party's control, which shall include without limitation, and then a long list of events, right? And then at the very end, or any other cause similar, dissimilar to the foregoing, not within the control of the parties. That's very broad, but not specific enough. And the court, of course, rejected Ruby Tuesday's argument. So the takeaways, other than that first degree contact that we're talking about, is that the broad language used in that clause didn't save the defendant. If you're going to see down the road that economic conditions might force you to change your mind about your obligations under this contract, then you've got to write that more specifically. A court's not going to like a broad clause that attempts to, where you sort of after the fact attempt to include a downturn in the economy as the reason for your excuse or your failure to perform.
And then also to finish up on Route 6, another point that the court talks about kind of in its initial discussions is that, and I'm going to quote from the court, when the parties have themselves defined the contours of the force majeure in their agreement, those contours dictate the application, effect, and scope of the force majeure. So again, even though courts construe these narrowly, they still hold on very tightly to the idea that you are in control of your own destiny. This is choose your own adventure. If you give us the pathway, the court will follow it. But as we've seen, though, they will take you to task on exactly what words you chose and what words you didn't choose. So choose very carefully. All right, so that brings us to In Re Old Carco. So this is the success story, right, of the three cases. This is the success story. And this is the force, that was the force majeure clause. And you'll see this one had kind of a unique set of provisions, kind of in the middle lower portion there, right under riot, acts of civil obedience, or sabotage. Sabotage is an interesting one that I haven't seen in a while. Change to economic conditions and productivity and technological changes. Now talk about a broad set of phrases there. Economic conditions, productivity, and technological changes. That seems like tomorrow. Tomorrow we'll have a new set of technology. So does that apply? Maybe, maybe not. We'll see the case on it at some point, I'm sure. But at any rate, so in this case, this harkens back to 2008. So we're in around the same time frame, Great Recession. Old Carco, from what I understand, is essentially old Chrysler before they became New Chrysler. And they had entered into a contract with a municipality to get certain tax rebates. And as part of that agreement, they were supposed to keep a certain plant running and create jobs for the local populace. But of course, when the Great Recession hit, things went sideways. And as we know, several of the big three had to get bailed out by the government and had to take loans and declared bankruptcy. And so it was a very tough time for them. And as and this is an important fact that we'll get into a little later with the court's analysis, is Old Carco before that had been trying to turn it around. And we'll explain why that's important in a minute. And as noted before, here, Old Carco argued, hey, we have in our force majeure clause, it says a change in economic conditions. Well, the Great Recession is a change in economic conditions. Court, please excuse us. And in this case, the court said, I agree with you. We're going to excuse it. And the court did, but it went into very, very intricate detail on basically 2 points. Was the Great Recession a change in economic conditions? And it concluded that it was. And then it went into, well, did it cause this? Was it the cause of what happened? And did you, Mr. Old Carco, take enough steps to try to mitigate this? And the court concluded yes and yes. Yes, it caused it. And as example, 2 out of the 3 big three had to declare bankruptcy. So obviously this was a very big deal and clearly outside of everyone's control. And it pointed out you have this provision, change in economic circumstance. And what did you do to mitigate it? And this is probably the thickest part in this case of the court's decision. And we'll discuss it again later as well. But it went into intricate detail. Several pages of facts on why it thought Old Carco had in fact acted to mitigate its damages, but I'll save those details for later.
And one thing I think is worth just pausing on for a moment, James, is that we've got two cases, Route 6 and Old Carco, both dealing with the 2008 economic recession, both dealing with companies who, because of that recession, don't feel they can continue to do what they obligated themselves to do under contract. And in one case, Route 6, the New York court says, applying Pennsylvania law, says, nope, there's no excuse performance here under your force majeure clause. Whereas in Old Carco, the court agrees that the economic recession was the actual cause of the failure of Old Carco and excused Old Carco's performance. And it seems to me, when you look at the two force majeure clauses against each other, one specifically called out change in economic conditions, as you highlighted, the other didn't. And that seems to make a big difference in the outcome of the case.
And oddly enough, through the various force majeure clauses we have seen, that is not a common insert. For one reason or another, a lot of force majeure clauses do not include protection for change in economic conditions. And the reason why we'll kind of discuss later, and it plays very much into why courts are so skeptical about these clauses and interpreting them broadly. So what are the lessons learned here? Courts really, really do not like excusing contractual obligations, especially based on economic circumstances. Courts certainly take the position that that, you know, part of doing business is economics change, right? So unless you specifically contract for it, they're not going to let you do it. And part of that skepticism, I think, is very well shown in a quote going back to Kyocera. And it says, quote, it cannot, so referring to the plaintiff, quote, it cannot now, by judicial action, manufacture a contractual limitation that it may in hindsight desire by broadly interpreting the force majeure clause to say something that it does not. That is probably the clearest articulation I have seen about why courts are skeptical about broadly construing force majeure clauses. It appears that their perspective is, look, you guys negotiated this. You sat down at a table, you came to your conclusions, right? This is what we're willing to have a deal to. We're not going to let you just get out of that. Maybe the reason that you didn't include an economic conditions provision is because you're the other side wouldn't allow it. They wouldn't agree to it, right? They didn't want this to be part of it. So the court is very sensitive to the fact that this has been negotiated at arm's length by smart people, and they don't want to undo that unless there's a really good reason or the parties have agreed to it.
All right, so one chapter of this webinar presentation is important to emphasize because we've been talking about how to strategically structure your force majeure clause to consider the sorts of events that you really would like to make sure you're allocating risk to deal with. And there's not a limitless escape valve with force majeure clauses. There's some strings attached, even when you intend to assert that there's been a force majeure event, an attempt to excuse your performance. And that is what we call the duty to mitigate. And sometimes the courts refer to that as really a duty to attempt to perform. So in addition to narrowly construing the force majeure clauses, the court continues to impose certain duties on the parties. So when the force majeure event occurs, parties still have an obligation to mitigate and to prevent foreseeable risk of non-performance.
And so, excuse me. So as I noted earlier in Old Ray Carco, the court really went through great pains to talk about this. It framed the issue this way: whether Old Carco took reasonable steps to ensure performance by acting to mitigate the impact of the crisis on the company. And it concluded that it had, because even before the crisis, it had had a turnaround plan. It was trying to move forward. Once the crisis hit, it tried to get funding through credit, the government, TARP, et cetera, but it just couldn't. It just wasn't available. So it tried, and the court acknowledged that. It tried very hard. The other side had argued, well, but Ford did not have to go to bankruptcy. So clearly, Judge, this was able to be dealt with. And the court said, no, that's not enough. We're not defining whether or not a force majeure event has occurred just because some other company was able to handle it. That doesn't mean that as to you, specifically in your circumstances, that a force majeure event did not occur. But at the end of the day, courts require you to do something. You can't just sit on your hands and say, all right, well, we've crossed this line, guys. You guys are in trouble. The courts just won't let you do that. You have to still act in good faith towards your fellow contractee.
I think that's another piece of the what I was talking about earlier, James, where we're sort of looking at old Carco versus Route 6 and saying, why the difference in outcomes? Why does the Great Recession count as a force majeure event in old Carco and not in Route 6? Seems to me it's not just the force majeure clause itself and the decision in old Carco and those parties' decision to include a change in economic circumstances. We know that the backdrop of all of this is that courts don't like the idea that a change in economic circumstances is going to excuse one party from performance. So when you've got that listed in your contract, great. But you're also going to need to show through the steps that old Carco took as an example, that the change in economic circumstances really did prevent performance because you attempted to perform. You took several steps to mitigate. You just didn't get there.
Right.
One kind of interesting recent scenario that I think brought to mind a lot of force majeure analysis for both of us was the grounding of the Ever Given ship in the Suez Canal. Whether or not Ever Given had anything to do with the grounding or if it was a weather event is one thing, but there's also a line of ships waiting behind Ever Given expecting to get through the Suez Canal. And I looked it up this morning. The route you need to take if the Suez Canal closes to get around the Cape of Good Hope is 15,000 miles longer. So the idea that, you can just sit there and because the canal has been blocked by the Ever Given, not do anything, it's probably questionable, right? A court might say, nope, you've got to take the 15,000 mile route. Even if that, even if your shipping costs are exponentially higher, you've got to mitigate, you've got to attempt to perform. And in that case, it might mean taking the trip around Africa because there just isn't a route through it.
Mm-hmm. Mm-hmm. So force majeure and COVID-19. We're just starting to see how courts are applying these principles to COVID-19. And the reason we're seeing it just starting to trickle through is in litigation. It takes time for cases to move up. Many of the cases where you start to get a stronger citation of law tend to be at the appeals level, and it can take a year or two or three to kind of get up there. So my guess is in the next couple of years, we'll start to see a lot more cases dealing with this. But at least one court has concluded and applied a force majeure clause to a COVID-19 context. And in that case, J&. Contemporary Art LLC, what had happened was they were trying to do an auction for art, and they had a clause in there that said that it's a force majeure if the auction is to be postponed for circumstances beyond our or your control. And the court concluded, well, COVID-19 happening and restrictions being in place by the governor is certainly outside of your control, and we're going to let you redo it. With that said, it's a little unclear whether other courts would go along with this, because postponed for circumstances beyond our or your control is kind of broad and it's a little loose. It doesn't necessarily reference specific government action. It doesn't necessarily reference pandemics or COVID-19. So it'll be interesting to see if courts continue this trend of kind of being favorable to it, just because this was such a worldwide impact in a way that even the Great Recession perhaps wasn't. But cases notwithstanding, it's entirely possible that this time around, businesses kind of talked with each other and worked it out, because everyone was impacted by this. Everyone had to stay home. Everyone had to change the way they've done business for decades to combat and deal with COVID-19. And so that's also another point that I think we want to emphasize here as litigators who usually get things kind of on the back end, is nothing stops you as a business from agreeing with your contractee, your fellow business, to say, look, we both agree that this situation stinks, so let's work through it, right? The contract may say one thing, but if you guys agree to handle it in a different way, that's great. Saves litigation, saves the courts having to work with it, and it allows you to come up with an individualized solution. Maybe instead of just saying, hey, we think this clause gets us out of this completely, we can say, okay, we get it. What if we delay? What if you give us an extra 15, 20, 30 days so we can figure out how to get this product to you? And maybe the other side in their business, say, you know what, yes, we can deal with another 30 days. We get it. We get the situation. We appreciate this relationship. Yes, we'll certainly give you more time. So business solutions are not beyond scope here just because you have a force majeure clause. So let's go back to our classic force majeure clause example and kind of look at this with a discerning eye for what we've just talked about. As we've seen, there are certainly clauses that are longer than this. There are some that are shorter. But what's important is the specificity. And we look at this, and it's easy to see how a court, looking at it very narrowly, could create problems, right? Government regulation. I'm going to really harp on that one because that's connected to COVID. What does that mean, government regulation? Does that mean if HHS here in Michigan says, well, you can only come into the office once a week? Does that count as government regulation? Does it mean an explicit order saying you can't sell this, you can't do this? Depending on the context, a court could maybe go either way. It's kind of broad and a little ambiguous. Civil disorder. What is a civil disorder, right? Is that rioting? Is that a protest? What exactly does that mean? And this is what courts will have to grapple with. When someone says civil disorder, it's going to hold you to your word. If you could have anticipated in your line of work that there might have been a protest in that area, or you could have gone around it, is that enough to be a force majeure? And then I want to kind of finish here on this language, making it inadvisable, illegal, or impossible to perform their obligations under this contract, or under this agreement. What does inadvisable mean? Does that mean that you don't want to do it anymore? You know, you ask your spouse, hey, should I do this? And they say, no, I don't think it's a good idea. Is that enough? Do you need to go to a professional? Do you need to go to a lawyer? Does it need to be unprofitable? How unprofitable? Do you have to lose $1 million, $1 billion, $5? It'll be hard for a court to discern what exactly that means. And as we've seen, if a court doesn't know and you're not very specific, that court will construe it very narrowly. And then, of course, illegal and impossible. That language is certainly more strict, and courts will have a better idea of that because, you know, they're courts. They'll know it's illegal, and there's already doctrines that talk about what is impossible.
All right, so we'll wrap up here with some conclusions, some additional takeaways. As we mentioned at the outset, force majeure clauses are a contractually based way to protect against the unforeseen and uncontrollable events. But courts are going to interpret and apply them narrowly because they, generally speaking, want to preserve the contract. They don't like to excuse contractual obligations. So you should think about the scenarios that you're most worried about and identify them specifically. Where you use a catch-all term, we've seen courts really aren't going to credit that. They want to see a more specific term addressing the issue that came to pass. And that does make it difficult because you're trying to predict the unpredictable, as we said. But you can work off of history, and COVID-19 certainly presents an opportunity to reflect on the certain events that came with the pandemic that really did make it extremely difficult for you to perform your obligations under contract. And you can turn back to your clauses now and think about how you should more specifically write in events that you would like to allocate risk for. James, before we go, any other thoughts on these key takeaways?
I mean, be specific, right? I think that's probably the biggest takeaway that I hope everyone leaves with today is be specific. If you care about a specific scenario, even if you really hope or think it's not going to happen, talk about it, put it in there. If you care about a change in economic conditions, put it in there. If the parties care about a very specific set of change in economic conditions, put it in there. Give the court guidance on what you want. Courts want to know what your agreement was. If your agreement is specific about what you want to change, what you want to have excused, they will honor it, but you have to be specific, painfully so if possible. Be painfully specific.
All right, and so before we go, I'll just mention first, thank you for joining us today. We really enjoy this Lessons from Litigators series that we're doing, and we hope you enjoy it too. If there is some issue you'd like us to talk about, shoot us an email, let us know. We've got a couple of webinars coming up that I'll highlight here. In about 3 weeks, we'll be doing on August 12th, a webinar about document preservation called Don't Shred That. Although I'll tell you, some of the advice we'll give, or not advice, but information, is that, there are times when you should destroy and there are times when you should preserve. And that's going to be specific to your company's needs. I'm going to be on that webinar with my colleague, Sarah Wascalnes. And then in the beginning of September 2, we'll have a great webinar with Matt Beccari on catching hands in the cookie jar, effective internal investigations. So we hope you join us for those, and we look forward to seeing you again soon. Thanks for making this a part of your morning, and we hope you have a great day.
Absolutely. Have a good one all.